Okay, ladies and gentlemen, welcome. Thank you for braving the cold, those of you who are in the venue. Those of you joining us online, thank you very much for that as well. This is the second of our exam skills seminars. Those of you who were here yesterday, you were here and we spoke about how we're going to use our class notes that we have and how we're going to use new methods of studying, i.e. mind maps, flashcards, mnemonic devices, and then spaced repetition, right? I hope that some of you have already started implementing some of those new skills. And then today we're going to see what do you do with those skills. So once you get to the exam venue, what are you going to do? How are you going to approach your paper? How are you going to approach the whole month that is the exams? Right. Before we start, there are two things with regards to the attendance. So the first is I have the attendance register for those of you who are joining in person. For those of you who are joining online, if you are joining with a private email, i.e. your Gmail account or whatever, please make sure that your name has your student number in, because yesterday I actually wanted to send you guys the slideshows and everything because there was a video that we couldn't play and it was difficult for me because your student numbers weren't already available. So those of you who actually received the email, no need to worry about that. Those of you who did not receive the email, you can just send me a private message and then I will have a look at the register that I have, which does have names but no student numbers. Right. And then we're going to look at how to write exams. So exams are a time of great stress for most people, but it is not necessary to be that stressful, right? So in this, we are going to look at how to prepare for a sit-down exam. We're going to look at how to analyze the instructions, answering multiple choice questions, true and false questions. Then we're going to look at how do I look at my case law, right? And then we're going to look at how do I correctly answer an application question. Okay, so it is a little bit of a longer session than yesterday, but it is hopefully going to be worth your while. Zig Ziglar said that success happens when opportunity meets preparation. So you are now in the phase where you are preparing. And when you get to write your first opportunity, hopefully no second ops, right? That is when you will reap the benefits. Okay. Unfortunately, that delay in the benefits sometimes leads to a decrease in our motivation. But that is why we advise you guys to write down your goals so that you can see them every day, right? Have some visual cues up in your room, in front of you when you sit at your desk, maybe you look out a window, write them down and paste them. Okay, because this gives you the visual clue. Maybe you're not sure, like, okay, I just want to pass this semester, right? That's fine, but it's too general. So then go and write your 50% for each of your modules down. Okay, so that you have that visual clue. Right. Let's quickly have a look at some general exam tips. So the first one is that you should know the venue and the time that you write, okay? It is a thing that we think that we should know, but till this day, if I'm stressed, right, and I wrote my last sit-down exam, I'm going to give away my age now, 10 years ago, right, when I was busy with my honors degree. To this day, when I'm stressed, I dream that I'm running to an exam venue and that I'm going to be late and they're not going to let me in. Okay, so it's very important. Take that stress off of yourself. Write down the times and the dates. This is also going to help you with those exam schedules that we spoke about yesterday. Secondly, bring the necessary stationery with you, right? With this, I mean the pen that you actually made your summaries with. because your brain associates that pen with the knowledge, right? You should have at least a pencil, a ruler, and one color in addition to your pens that you are writing with. Always bring a spare because you're not allowed to borrow, right? This is simple things. We know these things, but I'm repeating them because it does happen, right? Next, get a good night's sleep before the exam. So a good night's sleep is nothing less than 5 hours. Make sure that you have at least 5 hours of sleep. If you are a night owl, then you don't go to bed after 12, right? If you are a morning person, then you don't wake up before 4 in the morning. Give yourself 5 hours of decent sleep. Your brain needs that sleep to be able to work through the knowledge that you have gained, that you have put into it, right? Also, if you are going to go on 5 hours of sleep, please don't do that to yourself more than 3 days in a row because you're going to crash, right? So the whole thing about planning is about avoiding that crash, because it does happen when you overwork yourself and you are entering into this period that is a high stress time for you. Next up, nutrition, right? So 2-minute noodles, out, right? Apples, an apple a day, right? Make sure that you get good nutrition in. No, try and avoid the artificial stuff, anything from a packet, not good, right? Obviously, we stress eat when we are busy preparing for the exams, but try and balance it out with some fresh fruits and veggies. And then finally, if you didn't work hard during the semester, right? Be honest with yourself. If you did not work hard during the semester, you are in crisis managing mode, right? Lower your expectations and make sure that you are going to now prepare for what's coming, because you are going to work twice as hard because you didn't do your job during the semester, okay? Unfortunately, it's the hard truth. Unfortunately, you are not the first person, and luckily you won't be the last person. Most people survive it, okay? You will too, if that is the case. If that's not the case, then let's continue with analyzing the instructions. So this is instructions that came from a 371 paper, and they will always ask you similar things, right? There will be times when, for instance, you have to write the multiple choice questions on an answer card or something like that, right? Always write your student number, always write the date, always write the module code, and then also make sure that you write neatly and legibly, right? Some of us have an inherently unneat handwriting. That's fine. Just try and make it as easy for the marker to mark your paper, okay? Some of you will now say, oh, ma'am, it's their job to read, right? Which is fine. But if my marks were dependent on it, I would do the best I could to make sure that my marks are as best as they can be, okay? And then you will always see that last one, refer to the applicable case law and acts, right? We'll get to this now. So this is also instructions from a 373 paper, and this is where we see that answer section A on the multiple choice card. Make sure that you read those instructions. You might think that they're generic, that they're all the same. Sometimes there's something in there that you missed that could have saved you marks. Fine. Right. Then multiple choice and true and false questions. So we're going to do the multiple choice questions first. Okay, multiple choice questions and true and false, we think easy marks. So what does our brain do? Our brain relaxes and we make stupid mistakes, which we cannot afford because they are easy marks. Okay, so first things first, allow yourself 1.5 minutes per multiple choice question. Okay, if you take more than this, you're going to run out of time when you are at the application questions. Read the question, This is again something that we think is like an obvious thing, but it's not, because one word can change how you actually answer this question. Okay, we're going to look at some examples just now. Then the options there are not for you to inky pinky ponky. Ne? You have to actually know the content of the multiple choice. You should just have a confirmation like, okay, yes, this is the answer that I thought it was. It's number C. If you're going to sit there and inky pinky ponky, it's going to take you longer than 1.5 minutes, because sometimes those answers are really, really long. And the chances that you're going to be wrong is like 75% guaranteed, because if you have four options is 25% each, right? So if you choose one, it means that there's 75% chance that you're going to be incorrect. Okay. They use the process of elimination. If you're really not sure, right? If you read them, maybe they're like two that you know for sure is not going to be right. Then you can delete them or draw a line through them, and then you pick from the other two. Then at least your chance of being correct is 50% instead of being 25%. Right. So use the process of elimination. And then if the question has option E, all of the above, if you know for sure that A and C are definitely correct, then you can, with a, in Afrikaans we say 'n gerusde hart, so with certainty, you can then pick all of the above. Right. Right, so then let's have a look at a question. So this is a question from a 313 paper. Choose the correct option. A clause that appears at the end of the will and which declares that all parties were present and signed in one another's presence. It may also be, it may also record the place and the date of the signature is known as A. So now, there are all of these Latin terms, right? For sure, I know that D, mortis causa, means cause of death. Right? I don't even have Latin. I've never read Latin, but I know that mortis causa is cause of death. So I know it's not D. Modus is method, right? So it can't be A. Animus testandi, I might have learned from the textbook what that is, right? And then the one that kind of stands out because it's not a Latin term is the attestation, right? So that is going to be like, my mind is going to go there first, but just make sure that, okay, that is really the correct answer. Okay, for those of you who have 313, you would have been able to see that it's B, right? So it's that one that's not in italics or it's not in Latin. Right, now this one is different from the all of the above. The reason why is because there are like 3 statements and A and C can be correct, A and B can be correct. If we read those options, right, this is about when does someone function as a trustee in a business or in a trust, right? So the trustees owns, for purposes of administration of the trust property in accordance with the objectives of the trust. Now, again, I haven't had trust law, but it sounds like this can be correct. Okay, so A is an option. Then if we look at B and C, you can see that they cannot be true at the same time. So B says that someone is a trustee once they are nominated, and C says that someone is a trustee once they accept the nomination, right? Now, again, common sense to me says once you accept the nomination, then you are a member of the board, right? So C is definitely correct. And then you'll know if A is correct or not because you studied the work, right? So in this case, it is A and C, which is option. Okay, so use the process of elimination. Are you sharp? Okay, it's looked for a minute like you were a question mark there. Okay, so 1.5 minutes. process of elimination, know the work before reading the options. Okay, right, true and false questions. True and false questions, these are your time savers, but technically for a 3-hour paper, if it's 100 marks, you still have a 1 minute and 1 minute 30 seconds per answer or per question, okay? Again, know the work well enough so that they can't catch you up. Don't be like, is it true, is it false? Okay. Then, read the statement carefully. One word can change whether it's true or false. A word like but, a word like additionally, etc. Make sure that if a reason for your answer is required, that you write that reason. Typically, they don't want you to write a reason if the answer is true. It's usually only false. For false questions, they can ask you, give a reason for your answer, or they can say, rewrite this false statement into a true statement. And then you should know how. Right. These are going to be the words that are going to catch you out, right? They call them qualifiers. Words like generally, sometimes, always, definitely. They are the words that if they are not correct, they can change the entire sentence. Fine. Right. Let's have a look at the next couple of options or examples. So the first one says the Constitution is the supreme law of South Africa. That's true. But laws or conduct does not have to align with the Bill of Rights. Now, for me, if the Constitution is the supreme law of the land, then obviously everything underneath that should align with that, right? So, in this instance, I was clicking on the wrong computer, sorry. So in this instance, it is false because the Constitution is the law of the land and the laws in the bill have to apply or comply with the Bill of Rights. Okay, so that one word, that but, made that statement into a false statement. If you did not read that carefully, if you only read the first part of the sentence, verkeerd. Okay. Right. Then Section 9 of the Constitution states that everyone is equal before the law. Something like the word everyone, right? No one is excluded. That is also a qualifier, which means that this one is true. The statement is 100% true because everyone is included. Okay. Right. I think this is it for, yes, for short questions. Any questions related to either multiple choice or true and false? None. Okay, perfect. Right. So then let's move on to knowing your case law. So knowing your case law is important. Why? Because you're not going to be asked, what were the facts of the case in blah, 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 blah. You are going to say, according to the judgment in this case, I can say that these sets of facts have to be dealt with in this specific manner, right? So if you use the FIRAC method to look at something like this, it's just going to make it a whole lot easier. So this is a description of a case. In short, there was a burgemeester. What is his name now? Mr. Jones. So he was a municipal councillor. I just had to remind myself now. So Mr. Jones was a municipal councillor who like liaised with the opposing party, and he said that he's going to resign and then join that opposing party. So what he did was he wrote a letter, he submitted the letter, and then the next morning he felt like, oh, I made a mistake. So he went back to the person who he submitted the letter to, took the letter back, and the letter was not opened, although it contained his resignation, right? So now the legal question is, was the resignation valid or not? Okay, So let's quickly have a look at the FIRAC method. So the moment that someone says FIRAC or IPAC in the law faculty, people lose their minds because the way in which you remember it is very like segmented, and they want you to have like a general idea, right? So using the FIRAC method is good because it helps you remember. But the way in which you then restate the facts, right, should be in paragraph format, not in bullet points. Okay, short sentences, full sentences, and don't contradict yourself. Right. Okay. So the facts of the case we know. The issue or the legal question that we have to deal with, right? This is going to be present in the questions as well. So you'll have to identify them when we get to the application questions. Right. We'll get to an application question now. I'm just like putting it there. Then we have to know the rule of law. So the rule of law will be the stuff that you studied, right? If it's constitutional law, then you are going to have studied the Constitution or at least large sections of it before going to the exam venue, right? Then you analyze or apply, and this is usually where you lose it, okay? But we're going to look at how do you keep focus, right? And then finally, we write a conclusion. So everything up until the application and the conclusion is work that you would have studied, right? So we're going to look at how do I then put in that analysis, but we'll get to that. So let's first have a look at the facts of the case. So this is that same thing, right? But now I have my highlighter in the exam room. So the first thing I do is I highlight the facts of the case so that it makes it less for me to focus on. Okay, so now immediately I can see, okay, who is the municipal councillor? He submitted a resignation letter, he took the letter back, it had not yet been open. The DA resolved in that meeting not to take the matter any further. The ANC wanted the High Court to have that resignation be called valid, right? And then it asks if the High Court should or should not see that resignation as valid. So the facts of the case are that Mr. Jones was resigning as the DA ward councillor and from the municipality's council. Mr. Jones retrieved the letter before the 7 days provided for in the Municipal Act. Okay, so the Municipal Act, that's going to be our first rule of law that we have studied, right? What is the legal question? Under the circumstances, did he resign? And what constitutes a valid resignation under that Local Government Municipal Structures Act? Okay. 2 things here. No, I'm lying. 1 thing only, right? So I put it 1, 2, 1, 2, or in bullet points. You're going to write a paragraph. So instead of saying, this is the legal issue, this is the legal issue, you're going to write something like, the legal issue in this case is whether Jones' resignation should be seen as valid and what constitutes as a valid resignation under section blah, 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 blah. Okay, so it's about writing in fluid paragraphs, complete sentences, not bullet points, right? This is the way in which that IPAC method that we use is like your little cheap thing that you keep in your back pocket, right? But if you can't get away with it, then don't do it because they're going to get angry. Okay, so the rule of law then is that section 27A of the Local Government Municipal Structures Act that you would have studied, right? And Swart v. Vosloo is going to be in the prescribed reading. Right. Now, the sad thing is there is no easy way to remember 10+ case laws, okay? In Afrikaans, we call it hom op jou gat. Nee, you have to sit down, you have to study, unfortunately. The only trick that I have is when it says, for instance, swart wie Vosloo, you don't read it as the applicant, the respondent, the applicant, the respondent. You say, swart say, or swart was suing Vosloo for blah, blah, blah. Okay, so make sure that if the case is written in a way that says the respondent and the applicant, that you put in the names that are in the case name. Another thing is, if it's an Afrikaans word, right? So there was a student with me and she couldn't understand what is Boerboontjiefontein, right? It was one of her case laws. I can't remember. I think it was entrepreneurial law. Until I told her, no, a boerboontjie is a green bean. And then she was like, oh, okay, so it's a green bean farm. And I said, yes. So if it's like in Afrikaans, don't put a mental block to it. Google it. See if you can't find the word in English. Or if it's something like boerboontjie, then make up a mnemonic like we studied yesterday, or like we said yesterday. Okay, so boerboontjie, boer, you might say like, I don't know, the white guy, and then Boontjie, you might say, yeah, I'm not good with mnemonic devices, I told you guys yesterday, right? But make up names for yourself so that you can remember it easier. And then the other thing is a case has a backstory, right? So try and think of what is the backstory? What brought Swart and Vosloo to the point where they are now suing each other? What brought the ANC and the DA in, can't remember if it was Beaufort West, to sue each other for what happened, right? And if you read that case, you could determine that Jones was actually in a coalition with some of the ward members of the ANC. And he promised them things that he then didn't deliver. And the moment that you think of it as a narrative instead of a case, it becomes easier. Okay, so those are the little tricks, but unfortunately, if it's a lot, it's a lot. You can't lessen it. Okay. If there are like 3 cases to 1 set of theory, I would say safely you could eliminate 1 and then just study 2. If it's like to 1 specific set of theory, if there are like 3, eliminate 2, but never have less than 50% of your cases that you're going to study. Right. Right. And then the analysis. So now we have knowledge of what the Municipal Act says, and we have knowledge of what Swart v Vosloo says, right? And this is the example of what the analysis and the conclusion will look like. Okay. Later, I'm going to show you, okay, how do I unpack the theory and then how do I apply it? But I want you to remember that when you write it in an exam, it should be a complete paragraph, not bullet points, once again, right? So in this instance, the court based its answer on the proper meaning to be ascribed to the term communicate. So they focused on that word because communication, according to that Municipal Act, is in written format, and it should have been read by the person that it was given to. More specifically, the court placed a particular accent on the concept of unequivocally communicated. So unequivocally means no one can deny that it was communicated, without which there is no effective resignation. The court also recalled to mind the Swart v Vosloo case, although the latter case dealt with the cancellation of a lease agreement, so it wasn't a municipality thing. Is as much a legal act as is a resignation, which also bears the features of a cancellation. And then it says there, what was the judgment? Thereby, it reached the conclusion that in the current case, there was no effective communication because the letter wasn't opened. So if you were writing this and then you add there, because the letter wasn't opened, right? That shows the lecturer that you actually interpreted the case that you were busy with in the question. Yeah, because the employer didn't read the letter. Accordingly, the municipal manager's failure to read the written letter prevented full and proper communication, and the reading element is missing, so is the resignation, basically. Right, those of you that are getting in. Right, okay, so now we're going to look at application questions. So, the first thing that I can tell you is that for every 10 marks, you should not use more than 12 minutes. Otherwise, you're going to run out of time. Okay. So how do you approach application questions? You have to understand what is being asked. In this instance, I usually say it depends on how high your anxiety levels are. If you have like hyper anxiety, right, then go section by section by section, read through the paper and write in pencil what you can remember about that specific thing, right? If you don't have like hyper anxiety, go through your whole paper at the start. Take 5 minutes, analyze your questions, write down those concepts that are going to save you time later. Okay? But it depends on how well do you know your work, and it depends on how high your anxiety levels are. Many people say, I don't want to read until the end because then I know what's coming. Okay? Another thing is that if you like do multiple choice, don't do multiple choice A and then long question C. Well, your A and or whatever, right? Don't do that. So do section by section, long question by long question. If you want to start with the long questions and leave the shorter questions for later, that's fine. They will look for it, but it has to be very clearly marked. So say, for instance, now I start with question 2. Then I'm going to say, question 2, say for instance, now it's about that municipal act, and then I highlight that and I underline it, and then I answer the question. I draw a line underneath that. Then I say, okay, section A, multiple choice. Then I do my multiple choice. But those headings I then highlight so that the lecturer knows exactly where my answers are. Okay. If you want to start with the difficult questions, that is fine. Don't waste time on them. So if they are 20 mark questions, don't take more than 24 minutes, right? If it's like 70% finished, leave space open, continue, come back, because for that part that is there, you can already receive hypothetically 6 out of 10. But if you don't do your section A, you're going to lose 10 marks out of 10 because you spend too much time on your application questions. Okay, right. Make use of the case law and the legislation. Write in full and proper sentences. This is important. So I was speaking to some of the lecturers during the course of the 2 weeks, and what happens is your sentences are too long. And then the first part of the sentence and the last part of the sentence contradict each other, right? Don't let that happen. Rather, instead, where you think you should use a comma, rather put a full stop, start a new sentence. Okay, that's like a good rule of thumb to use. If you want to write a comma, rather put a full stop and then write a new sentence. And then finally, we use the IPAC method. So this IPAC method, that is where everybody loses their minds, but if used properly, you can actually manage it. So the first thing that we do is we have to understand the question. When I look at this way, this is one question from a succession paper. I don't know. How many third years are here? Okay, so a lot. Okay, so this is a third year. For those of you who are not third years, succession paper. And this is actually one question out of that paper, right? And if I look at this, I would get a fright and I would run. Okay? But the moment that I use a highlighter, it becomes easier to read. So if I've actually read it, we say, or the question, you have the facts, and then you have what is expected of you. And this is actually written in that question. It says, what do we expect of you? What must you do? Right? So You, John Khumalo, validly executed a one-page will on 19 June. So you have the person and the date. Please find the said will on page 9 of this paper. It was annexed. The residential property situated at 1 Church Street, Lichtenburg, is bequeathed to your son, Joe Khumalo, in clause 3.2 of the said will. You had a huge fight with Joe on the 31st of December, 2022. So now this is like, does that have anything to do with the will? Do you have to say in the will, oh, I had a fight with my son, that is why I'm not leaving the house to him anymore? No, you don't. You just have to change the will. It's easy as that. And that's where some students lost the plot a little bit because they wanted to write there why was the will changed, etc., etc. Okay, so read that whole thing, and then it says amend clause 3.2 of the will on the will itself, page 9 of this paper, again, in full compliance with the requirements prescribed in section 2(1)(b) of the Wills Act. Okay, and this is the difficult part because you should have actually known that section. I had to go and look it up because it's difficult. Right, and you lost the will of your arm, so you are using an amanuensis. Okay, so what does that look like? Oh, getting an order. Okay, so this is the will that was written there, right? And you have to now change that part that says, I bequeath the residential property situated at 1 Church Street, Lichtenburg, to my son, Joe Khumalo. You have to change that. It's now Jolene's house, right? So big family fight waiting when John dies. Okay, so how do I do that? Because I studied, I could go and I could amend the will, right? So because I'm using an amanuensis, they had to actually sign for the will. They were to Jolene Khumalo, so that is the amanuensis that wrote that there, and they had to sign. Then your witnesses had to re-sign the paper, or you had to get new witnesses, and that would have given you a mark each. Then John Khumalo should have been should re-sign, and again, this is where the amanuensis would have signed John Khumalo's name, and then the most marks are for this certificate in terms of section 2(1)(a), which you had to study, unfortunately, and you would have gotten marks for, in my capacity as Commissioner of Oaths, I have satisfied myself as to the identity of the testator and then the signature there of that person. Okay. Unfortunately, once again, no easy way. Study, 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 repeat, repeat, repeat. Okay. Anybody who is unclear of how to understand a question. Understanding the question is half the battle won, because if you know what is being asked, right, then you can answer. But the moment that you only read half of the question, you're going to make mistakes. So give yourself a minute, take your highlighter, take your pencil. If you're someone who doesn't like to highlight, right? If I have to use a pencil, then for instance, facts of the case, which is in blue here, then I draw little brackets and I actually number them 1, 2, 3, 4. I double underline the words that are doing words. So the verbs, I double underline them. And then the theory, like that section 2(1)(a), I would actually make like little squiggly lines underneath that. So find a method that works and work with that method. Right. Okay. Okay. Now, the IPAC method. Importantly, once again, the IPAC method is your little secret. Okay. There shouldn't be any way for the lecturer to know that you actually use the IPAC method. Okay, it's your way to unpack what you are busy with. The issues that you identify from the facts that they give you is the I. So in this instance, you would say, I deduce from the facts given that there is contestation about whether the will of Joe Khumalo is valid or not. Simple as that. okay? Then you say, what is the legal principle that this is based on? So this will be where your case law comes in. No, I'm lying. Yeah, no, this is where your theory is going to come in, right? So your case law and your theory is going to come in here. Then you have to apply, okay? So first you will say something like, I refer to the Wills Act of 1992. Under the Wills Act, the validation of a will is determined by the following facts, and you give them. In this case, Joe Khumalo did not adhere to points 3 and 8, which means that the will is not valid. Okay, right. And then finally, your conclusion. In conclusion, if Joe wanted the house, Joe could have taken the house because Jolene, or the will that stated that Jolene is now the new inheritor of the house is invalid. Fine. So let's look at an example. Anybody who has questions on this? No questions. Okay, perfect. Right. So this is an example question from 373 paper in the semester week, right? Contracts. So it has a little scenario given to you. One day over lunch, two friends, Sam and Msibi, agree that Msibi would sell. Oh, that has a little bit of an English error there. Would sell his 2023 Mazda CX-3 for the price of 780,000 to Sam. So they agreed on the price. They agreed on what is being sold. They agree that the payment will be made the following day, and Sam will take delivery 1 week from their lunch meeting. Sam makes payment, but when he calls Msibi to arrange delivery, Msibi explains that he was joking about selling the vehicle. He says he will return the purchase price to Sam, and Sam is very unhappy. Right. So now it says here, our law of contract offers various theories of contract to assist in determining the liability of the contract. So is Msibi liable? Should he give the car, yes or no? That's basically the legal issue, right? The liability of the contract. On what basis will a court determine if a valid contract of sale was concluded? So Professor Viljoen actually identified the legal issue for you in the question, right? In your answer, you must set out and provide a complete inquiry on the relevant theory of contract supported by case law and provide a complete application. So firstly, if I have my highlighter in hand, I can see that that is where my legal issue comes in. Was he joking, and should he still give up the car? Right? The issue is whether Sam and Msibi had a valid contract after the agreement of payment and delivery. That's the legal issue, right? So again, you can say this, you can say here, was Msibi joking or not? The issue is blah, 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 blah. Okay. Right. So for identifying the issue, you won't get a mark. Why? Because the issue was identified in the question, right? But you have to restate the issue because otherwise the application and the legal principles won't make sense, right? So the first statement is, I understand this question, right? I know what I'm supposed to do. Now, this subjective objective approach that states that the reasonable belief in the existence of consensus according to a reasonable person is the basis of contractual liability. This you would have studied, right? And the reasonableness of the belief will determine whether the contract fails or stands. So if Sam and Msibi are both reasonable people, no one is crazy, right? Will the contract stand? Okay, and for identifying that principle, you would have gotten 2 marks. Now, how do I support what I just said? That support comes from the case law that I had to study. And if you study one principle one case law. It will hold up in your argument. Okay, so again, study two just to be safe, but if you have one principle with one case, it should be fine. Okay, make mnemonic devices. So for instance, Stein was reasonable, but LSA Motors was subjective objective. So that you have that little rhyme so that you know, okay, this case goes with this objective. Okay. And because you knew that this case and this theory goes together, you would have gotten 2 marks again. Okay. Importantly, so you would have said something like, the liability of the contract explained in the question is based on whether both parties are reasonable. Okay, so it's about that formulation. And then at the end of that P, that big block, right, you say, this is confirmed in the case of Stein v. LSA Motors. In that case, this and this and this happens. Okay, right. Then we get to the application. So now we have to look at what is the reasonable part and why does dissensus happen? And these 3 questions are from the textbook, right? So the theory is, did the contract denier, who is who? CB, because he doesn't want to give his car away, right? Misrepresent his or her contractual intention. Yes, because he said, sure, pay me the money, I will give you the car in a week's time. But then when it came to delivery, he didn't do that. Did the contract assertor, who is who? Sam, right? Because he wants the car, so now he's asserting that there is a contract, rely on that misrepresentation. Yes, because he thought he was getting a brand new car for half the price that it is on the floor, right? So he made reliance because he actually paid. The proof of that reliance is in the payment. Okay, and was the contract assertor, again, this is Sam, was that reliance reasonable? Yes, because CB said, I will give you the car in a week's time. Okay, now the awkward part is that up until now, right, 10-mark question, 6 marks is the only theory that you would have studied, right? So saying that I can't pass an application question is not a valid excuse, because the application, the hard part is only coming now, but we've already gotten 6 marks. We already have the legal principles that we've identified, right? So why can you say that there is a valid or there is not a valid contract? We have the case law and we have the theory of that reasonable contract assertion. Now we only get to the application. So the following 4 marks will be that application. What have I done? So I've taken that theory and I've made little spaces in between, right? So the previous paragraph would have been something like, the 3 questions to ask about whether a valid contract has been formed are, and then you list those things directly from your textbook. Now you have to use the names of the people in the question. So the contract denier misrepresented, misled his or her contractual intention, right? So you say, in the first instance, right, because you're referring to point 1 in the paragraph above. In the first instance, determination of the purchase price, specifications of the vehicle, delivery date, acceptance of the payment by CB the following day, and CB led Sam to believe he was serious. So instead of then saying the contract assertor, contract denier, you use those names. Sam made the payment in reliance that CB would deliver. So you say, following this reliance, Sam paid CB the money. That's the only thing that you have to say, right? Which means that he thought that he was getting the car. And finally, any person having had the discussion and come to an agreement on the material terms, right? The material terms, price, date of delivery, and what the product was, as set out under A, so that's point 1, would have a reasonable reliance that CB had the necessary animus contrahendi, which he would have studied, to conclude a valid and binding contract. Okay, and then finally, your conclusion. Although there is a dissensus, so a disagreement, you could use the word disagreement because it's a synonym, it means the same. Some had a reasonable reliance based on Msibi's conduct. So what Msibi did, how he agreed, Sam was reasonable in thinking that that's fine. And that is why Msibi will be held liable. He will have to give up his car, right, if this goes to court. And there we have it, 10 out of 10. Easy peasy, right? Okay, so how do you do this? How do you do this on your own? You have your old test papers, right? You might not have old exam papers, but you do have test papers of this year. Use them, practice, okay? It's not about knowing which questions are going to be asked in the exam. It is about knowing that you have the skill to understand the question and to answer the question. And rather study or try and apply these, write out your essays while you have the textbook, right? Learn that skill for yourself before you start, or while you study the theory. Rather than getting to the exam, knowing all the theory and then not knowing how do I put this theory into an essay. Okay. And that is where I come in. If you are, let me just make sure that this is the last one. Okay, so that's where I come in. If there are questions that you don't understand, or you have written a test and you don't understand why did I get these marks, right? Make an appointment with me and we can go through them together, right? I don't bite. I heard yesterday there was someone here who said to their friend that I'm scary. I'm not, I promise, right? Please come and see me if you have any questions, if I can help you with anything. Okay, my door is always open. If it's closed, there's someone crying, but I didn't make them cry, I promise. Okay, you can always also just send me an email, or most of you were here yesterday, that email that I sent with the slides from yesterday, at the bottom there's a link. If you click on that link, it goes to a bookings page. And on that bookings page, you can then just pick a date that suits you. Okay, a date and time. If it's not available, then I'm not available. Then there's someone else already booked. Okay. Are there any questions? Right, online, any questions? Maybe after. Any questions? Okay. Go and be productive, people. I will see you hopefully during the course of the exams. Hopefully you guys are now so skilled up that you're going to do brilliantly. Okay, goodbye. Stay warm.